In most states, district attorneys and prosecutors have a 98.5 conviction rate on these types of cases. That means that defense attorneys have a 1 to 1.5 win rate. This is not our win rate. Our win rate varies each year. We're about 40 to 60 times higher, and here's why. Public defenders usually handle about 350 cases per year. There are only 220 work days in a year. When you do the math, you can understand. Private attorneys, depending on the attorney, probably handle somewhere between 80 to 125 cases. The typical criminal defense attorney is paid a retainer and immediately tries to get the best plea bargain that he can for his client. For example, we get at least a phone call a month from a client that has been sold a bill of goods by a large Yellow Pages law firm, and we call them Yellow Pages law firms because they advertise that they are the best at everything. They are the best at burglary, they are the best at murder, they are the best at assault, they are the best at rape, they are the best at child abuse, they are the best at bunco, they are the best at everything. Just look through the Yellow Pages and you'll see for yourself. At least once a month we get a call from a client that has paid a large retainer to one of these Yellow Pages law firms. And they never see the attorney that took that initial retainer again, because typically that attorney is paid a very large share of the retainer and does a very small portion of the work. You see, a very small portion of the retainer goes to the lawyer that's actually going to do the work. The attorney that took the big share of the retainer is called a closer. He or she closes the deal, gets the client to sign up, and then the attorney that's given a small share of the retainer basically tells the client the case is hopeless. They've got to plead to some sort of lesser offense, and these people find themselves entering pleas and not really understanding what's going on to them. And they end up serving many years in prison. We don't do that sort of thing. We are not part of the 1.5 percenters. We only take 10 to 12 cases a year. We treat each case like a murder case. In fact, the sentences in child molest cases are longer than in murder cases, except for those murder cases that get the death penalty. We start preparing the case for trial on day one. We are quite aggressive in our preparation. We scan in all of the documents, all the police reports. We index them so that we have control over the entire file. We take audio tapes and videotapes. We digitalize them. We put them into the computer so that they can be used later in our courtroom presentations and for our closing arguments. Often, we are successful in getting cases thrown out before they even reach a jury trial. From the very first moment we start with a case, we open up a document called a jobs list, a document called a witness list, and we index all documents and outline every witness. For example, as we're going through the thousands of pages in any particular case, we read it very slowly and highlight every issue that's of importance. We take witnesses' addresses because you never might know on page 65 whether that janitor is important, and you see his address on page 65, but you don't learn that he's important until page 655. But then how do you know what his address is? That's why we write the addresses down and the names and the contact information as we come across witnesses' names. We index absolutely everything and keep it electronically. Another difference between how we handle these cases and others is that we can teach you anything that we do. This is important because our philosophy is to involve you in your case. It's your case. The DA will make an offer. They usually do, even if you don't want one. Our philosophy is to educate you so that you can make an informed decision rather than one based on fear and ignorance. This is why we are not part of the 1.5 percenters. There's hope with respect to these kinds of cases. Now that you understand the politics and the seriousness of these cases, we want to get together and discuss the facts of your case. We want to hear if there are any charges that have been filed yet. Maybe we could stop them from being filed. We want to know what kind of interaction there's been between the police or the CPS or the children's services or therapists and your family members. We want to know the events in chronological order absolutely every event, even events that you may not think are relevant, may turn out to be relevant later. We want to leave no stone unturned. We want to know if there are any prior complaints against you or prior complaints made by your accuser against someone else. You can survive this. However, we found that everyone touched by these difficult cases is scarred. We believe that preparation is what wins cases. Because we refuse to be lawyers like those 1.5%ers, those yellow page lawyers. That's why our win rate is dramatically different than that. We call them yellow page lawyers because they pay very large fees to have those big ads in all of those phone books. We don't do that. Why not? Because we spend our resources on your case and preparation to win your case. We don't advertise that we do everything. We don't do embezzlement cases. We don't do robbery cases. We don't do bribery cases. We don't do cases that take us out of our specialty area. We only do abuse cases. Your case is the most important thing there is to us. You see, defending against this kind of case is costly, both financially and emotionally. One thing that you have to realize is that if you don't give this fight everything you can, if perchance you lose, you'll be second-guessing yourself for the rest of your life. We can't guarantee that every client that we take on will win his or her case. But you have to remember that anybody that tells you that is lying. We can tell you that everything that can be done will be done. In this way, we maximize your chances of the best outcome.